Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with this week's immigration news. We begin with Supreme Court allows Texas to deport migrants. The Supreme Court on Tuesday gave Texas officials permission to jail and prosecute migrants suspected of crossing the U.S. southern border without authorization, greenlighting the enforcement of a state immigration law known as SB 4 that the Biden administration has called unconstitutional. Passed by the Texas legislature last year, SB 4 criminalizes unauthorized migration at the state level, making the act of entering the U.S. outside of a port of entry, already a federal offense, into a state crime. It also creates a state felony charge for illegal reentry. Texas SB 4 immigration law is a disaster for Texas and the nation. District Court in Texas allows CHNV parole program to continue. On March 8, a federal district court in Texas dismissed a challenge to a parole program set up by the Biden administration to allow 30,000 Cubans, Haitians, Nicaraguans, and Venezuelans to enter the United States legally each month, known as the CHNV parole program, allowing the program to stay in place. Judge Drew Tipton of the Southern District of Texas dismissed the claims brought by several states challenging the legality of the CHNV parole program. Judge Tipton held that the state of Texas, the lead plaintiff in the lawsuit, did not show it would be harmed by the CHNV policy because the program has successfully reduced overall border crossings, and therefore Texas lacked standing to bring the lawsuit. The dismissal means that nationals from the 4 impacted nations can continue to seek parole into the United States through the CHNV process. The U.S. is still sending Haitians intercepted at sea back to Haiti despite the violence. Despite extreme violence, political instability, and hunger engulfing Haiti, the United States is continuing to return Haitian migrants interdicted at sea back to the gang-controlled country, to the dismay of Haitian advocates in the U.S. who decried the policy. Recently, the U.S. Coast Guard stopped 65 Haitians who were trying to flee Haiti by boat and sent them back to Haiti, the agency said in a statement. There is a specific disdain when it comes to Haitian asylum seekers, said Guerlain Joseph, a human rights advocate and co-founder of the Haitian Bridge Alliance. The first U.S. act is not how do we protect the people, it is how do we deter them and how do we make sure they don't make it to our shores. Meanwhile, in New York, adult migrants limited to 30-day stay and right to shelter settlement. New York City can restrict shelter stays for adult migrants to a single 30-day placement, with extensions granted only under extenuating circumstances, according to the terms of a settlement reached Friday, March 15, between city officials and homeless rights advocates. The agreement between City Hall and the Coalition for the Homeless, after 5 months of private negotiations, also gives the city broader latitude to deny shelter to adult new arrivals without children if they determine they have the means to stay elsewhere, as well as migrants whom the city deems haven't made sufficient effort to find a place to live before their 30 days in shelter expire. The status quo could not have worked in this situation, said Deputy Health and Human Services Commissioner Ann Williams-Isom, speaking at a news conference outside of Manhattan's Supreme Court shortly after the proceeding. NYC Comptroller lauds the economic benefits of immigration legal services. New York State could generate billions of dollars in new economic benefits if it provides all asylum seekers, migrants, and others facing possible deportation with their own lawyer, according to a new report from New York City's comptroller. Comptroller Brad Lander, a Democrat, said the move would prevent the deportation of up to 53,000 people statewide, resulting in an estimated net benefit of $8.4 billion for the federal, state, and local governments, based on projected new tax revenues over 30 years, minus outlays for services. Access to work authorization leads to higher wages, the comptroller's report said. The higher earning power generates more tax revenue. Higher personal income also benefits the economy through increased consumer spending. In other news, USCIS updates policy guidance clarifying expedite requests. USCIS is updating guidance in the USCIS policy manual to clarify how it considers expedite requests related to government interests and requests related to emergencies or urgent humanitarian situations, including travel-related requests. This update also clarifies how to make an expedite request and explains how they process expedite requests. Differences in state sunshine laws can threaten transparency around immigration detention and enforcement. The main way in which the public can access information about what the federal government is doing is through the Freedom of Information Act, FOIA. However, laws that allow the public to get state public records, also known as sunshine laws or public records laws, are different from state by state. State and local government entities often can interpret their respective state sunshine laws differently. As a result, requests for the exact same information can lead to records produced by an entity in one state and shielded from the public in another, and, in some cases, released by one local government entity but not produced by another in the same state. The hodgepodge of state sunshine laws can lead to unjustifiable gaps in transparency around immigration enforcement and detention. Despite progress, the tragedy of family separation can never be undone. At home, a rival political faction had been making death threats against him and his family that compelled him to take his daughter to the United States to seek asylum for them both. But this was 2018, the era of family separation. As soon as the pair arrived at the border, Customs and Border Protection forcibly took the man's daughter away. They sent him to a detention center, and his 5-year-old was sent by herself to a separate facility on the other side of the country, 2,000 miles away. He wouldn't be able to speak to her again for nearly a month. Once he was allowed communication, it took the form of weekly phone calls. As this was unfolding, a lawsuit called Ms. L versus ICE was progressing through federal court. The American Civil Liberties Union was suing the government on behalf of a woman from the Democratic Republic of Congo and her 7-year-old daughter, who had also been forcibly separated by the U.S. government at the border and sent to separate facilities on opposite sides of the country. Finally, From Trump says, some undocumented immigrants are not people. Former President Donald Trump said at a recent rally in Dayton, Ohio, "I don't know if you call them people," he said at the rally. "In some cases, they're not people, in my opinion. But I'm not allowed to say that because the radical left says that's a terrible thing to say." Thank you.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.